reasonable belief that those statements are true. The complained of party, you, then have the opportunity to answer the complaint. When you answer a complaint, you can admit the allegation, because they number them, and so you can do each one separately. You can admit the allegation. That is saying, yes, it's true. You can deny the allegation, say, no, that's not true, or it really more should be read as saying, prove it. Or you can say, look, I have no idea. I don't have enough information to answer whether this is true or false. And then there's a few other things you can do, like certain allegations lend themselves to explanations or just, come on, guys, this is quoted right from the code. We don't need to deal with this. That kind of stuff. What your attorney is saying is, based on what you know right now, you have, in your opinion, and apparently in counsel's opinion as well, you have enough evidence to prove that you're a resident of Salt Lake County, that it is more likely than not you are a resident of Salt Lake County. Then, here I have to guess a little bit, but after saying you're a resident of Salt Lake County, your brother has listed some other things in that first paragraph. And what your attorney is saying with that answer is the rest of this paragraph, we don't know what you're talking about.
Mm-hmm.
Therefore, we're going to say it's wrong, prove it otherwise. So basically what they've done is they've gone through it, everything that is legitimate, they'll admit. Everything else they're going to deny, because the denial is they have to prove it. You don't have to prove anything.
Mm-hmm.
They have to prove it either by your admission or by a preponderance of evidence. And so what counsel has done, the way that they have phrased it, is a protection for you, because if you deny an allegation that you know is true, that they can produce evidence showing that you had actual knowledge it was true, then there are penalties separate from the rest of the case. And so you can get hit for attorney's fees, you can get hit for fines, you can have your answer canceled and face a default judgment. It's a lot of nasty things. And so what counsel is saying is, we're denying this, but we're denying it because we don't know. And so that way, if it comes back that there's actual evidence that you did know, you didn't flat out deny it. You said, I don't know. And when it comes before Judge Faust as to why did you deny this if you knew it was true, you say, I forgot. I told you in my answer, I didn't know. I couldn't remember. So what counsel's done is actually done you a favor in how they've written that, because it protects your butt from getting bitten by by having something turn out true that you should have known was true.
Mm-hmm.
That's what they've done.
So how do I hire, I called all these different representation, but because I believe my brother utilized the executor over the will to cancel my cell phone. I mean, he ahead of time warned me that he was only going to allow my daughter to have her phone for a month. I've been paying for years on all these phone numbers since my daughter was 16 years old. I gave my daughter my mom's cell phone number, and then I lost access to my own cell phone and my daughter, who has autism, that this is her legal address for Social Security.
Who actually owned the account?
I did. Well, my Social Security was tied to it, and it was coming directly.
No.
Yeah.
The phone account.
Yeah, the phone account was me. I was paying for it for my mom for the last.
I know you were paying for it.
Oh. Mm-hmm.
Who owned it?
Well,
Whose name was on the account?
it should be both my mom and mine.
Whose name was on the account? I don't care what it should have been. What did it say?
Oh, on the account for Ina?
For the cell phone contract.
The cell phone contract was originally under Ina and Susan at 3 cell phones.
Okay. Now, are you sure you were joint owner?
Yes.
Joint owner?
Yes. I paid for it for more than a decade.
Who paid for it is irrelevant.
Oh.
Okay?
Mm-hmm.
Probate is not a court of it. It is a court of law.
Okay.
We deal with what the document says, not what it was supposed to say.
Okay, so here's the thing. If it came out, which it did, directly out of my America Federal Credit Union, and I still can't figure out why and how my mom being on the account and that she helped set it up when my brother worked for Sprint, and it was actually during Sprint Nextel when my daughter was 16, which is almost 20 years ago. So her cell phone number was obviously registered directly to her. But then later we started a whole new contract after I sold my property in Aurora, where I came and I set up a new account when I went to T-Mobile before she passed away. We spent a whole day there attempting to fix the account when I bought brand new phones. I brought 3 brand new phones, which started a new contract. And that new contract automatically withdrawn from my checking account. So the fact that my brother came here after Christmas, after I just spent $1,600 on him, deposited $2,000, so that's $3,000 right there, plus $1,000, so like $4,000 on him, and he didn't even give me nothing for Christmas. Then he shows up here and he tells me about how, he plans on only letting me have my daughter's cell phone for the next month, possibly. And he's never paid a dime towards anything in my life, everything I've always paid for. And I didn't understand how out of bounds he was about my daughter's phone, but I had no idea that he was going to be able to figure out how to cancel my cell phones.
If he is the personal representative / executor / administrator of the estate, and if your mother was the owner of the account, then as executor, he has the authority and probably obligation to cancel the phones.
He made it where I have no cell phone. No, here's the thing. My daughter's missing now. I have no way to talk to her because he canceled her cell phone. The idea, and now...
Let me stop you right there.
Mm-hmm.
This is a court of law, not a court of equity. All we care is what the documents say, not what's best.
Mm.
Okay?
Mm-hmm.
Probate is very much rule.
Mm-hmm.
One of those rules is whoever is appointed personal representative has the right, duty, and obligation to manage all of the debts and all the liabilities of the estate until such time as the estate can be closed. So, if that contract was part of the estate, then your brother had an obligation to do with it what he felt was best for the estate. Whether that was best for you and your daughter is not material, it is not important, it is not relevant, it is not even considered. Okay?
Mm-hmm.
The only question that has to be answered here is, yes or no, did your mother own the account?
Okay. So the fact that...
She owns the account, everything else is within his control.
But the fact that I redid a contract when I bought brand new phones at Christmas time, I believe...
If at that point you took ownership
yes.
of the account...
Mm-hmm. I do believe I did, yes.
The documents show that that's what...
Okay.
Then he screwed up.
Okay.
However, the other side of that coin is if you owned it, he couldn't cancel it.
Well, that's what I'm wondering is how did this happen? Because the fact that it was coming...
I'm gonna bet you dollars to donuts. Whatever T-Mobile did, you were not the owner. I mean, I almost guarantee you that for whatever reason, they put in your mother's account name because that's what Sprint said. And so they just took the contract and went, oh, okay, and filled it out out the same, and away you go.
Even though it's coming automatically payments out of my account and I can prove how much money I spent and that he never spent a dime and that came directly out of my bank account, had nothing to do with the state?
An equity argument, it doesn't apply.
Okay.
You can make all of the, well, I paid for this and I paid for that and woe is me and blah, blah, blah. My daughter pays for probably a quarter of our groceries. Okay? If I decided to change my will and give everything to my next door neighbor, even though she's paid for a quarter of the expenses 10 years of her life, it has no bearing whatsoever. It just doesn't matter. All that matters is, number one, what does the will say? Number two, what is your brother doing? Number three, is there any conflict between number one and number two?
And as executor and me beneficiary, and my daughters being the only grandchildren that are supposed to receive anything.
Doesn't, unless what he's doing is in direct conflict with what the will tells him to do. For example, if the will says he is to ensure that your daughter has adequate telephone coverage for the rest of her life, then he would have to set up some kind of recurring payment to keep her in a cell phone for the rest of her life. Otherwise, he would be in breach of his duty. However, if it says instead that he is to manage the assets and liabilities of the estate, which is the position, then he can cancel anytime he wants to. What you're looking for and what your attorneys should be looking for is any actions that are contrary, not best interest, not to your daughter's best interest, not to what you want to happen, not to what you think is right, fair, or appropriate, contrary to the specific directions of the will. Those are his fiduciary duties. Now, there's a few more duties provided for in the probate code. For example, he can't waste resource, meaning if there's no specific, do lessons like with the house. If that's not there, then his position is that he's got to care for it in a reasonable manner or liquidate it. He can't waste it. He can't just let it sit there and rot. There's a few of those in the probate code, but mostly it's whatever the will says he has to do, that controls. And you need to chill out and let your attorneys deal with this in the appropriate course of action. You are not going to get a solution tomorrow. No one is going to get a solution tomorrow. The possible outcomes tomorrow are Judge Faust complete, which would mean that he's read the documents and determined that your brother is, without doubt, the personal representative, and what he's done is not in breach of his fiduciary duties. And he then issues an unlawful detainer, which becomes two things. Number one, it becomes a judgment against you for certain amounts. It can be unpaid rent, it can be attorney's fees, it can be future rent. There's a bunch of crap goes into it. Most of it doesn't apply in your case. The other thing it becomes is a warrant for your removal, which means that your brother can show up with the sheriff and haul you out. That's your worst case scenario. Do I think that'll happen tomorrow? Probably not. But it is a possibility. Other end of the extreme, and this won't happen, but the other end of the extreme is that he takes a look at everything and dismisses the case. The reason that I say that won't happen is because we're too early in the process. And the one tool that is used for dismissing a case this early doesn't apply in this case. It's called a 12B6 motion, and it's basically that the plaintiff hasn't pled anything that can be dealt with. Even if you believe everything he says, so what? It doesn't give him a right of any kind. That's not going to apply here. Somewhere between those two. Most likely, he's going to set it forward for a real hearing. Okay, because tomorrow's not going to be a real hearing.
Okay.
Tomorrow's going to be a real short, wham bam, thank you ma'am. You're going to be part of the law and motion calendar, and it's only going to be a couple of minutes. So what he'll do is he'll set it forward for calendar. It's right now, most of the stuff that I've got, 6 or 8 weeks. But that was a lot of end of the year stuff. So you may get a little shorter, you may get a little longer, but figure about 6 weeks. Whether you will have to move out during that 6 weeks will probably be discussed. Your attorneys will argue that doing so is unfair, that they want a temporary restraining order preventing you from being evicted. There's a bunch of different avenues they might take to keep you in. I don't know the facts well enough to even guess which one would work. Your brother may agree, look, fine, she can stay there for 6 weeks. Your brother may decide, no, I want her out. And he'll have to give a reason why you should be proven, ordered out. And then it'll be a matter of the judge comparing. This is the one point at which equity would come to play in your case, and that's because we're working now under landlord-tenant law for just this decision. And so the judge is going to look at, well, which is more likely to be the worst harm? You kicked out right after a major snowstorm, or a 6-week delay in listing the house for sale. Judge Faust is not a huge fan of what's called law and economics, where we do everything by dollars. He doesn't particularly care for that. He cares more for human beings. So my guess would be he's going to lean closer to the set it forward, and you can stay there until the hearing. That would be my guess. Other combinations of what I've discussed could happen, but I mean that's really all you've got is there are questions here as to whether your brother's behavior was in compliance with his fiduciary duties, but I don't think at this point you have filed them. Your new attorneys they may not want to touch it. I don't know. I don't know that firm terribly well. But that's really all I can tell you. And I'm not going to get involved to try and supervise your counsel. That is so unprofessional. It is absolutely unexplainable. So that's what I would suggest is just take a chill pill. Recognize that the answer is phrased the way it is for your benefit. And tomorrow you'll see where you fall in the continuum of possible outcomes.
Okay.
There's really no way to predict beyond that, all right?
Okay.
I gotta go.
Thank you.
Thanks. Bye.
Bye-bye. It's interesting is on all these movies, they never show a situation where by having no registry to will, I didn't know that. My mom, she would have known that. It would have been different. I mean, to know that she chose John Buckley based on him in his religious belief system. To know that she made executor over the will of my brother because of the fact that he's a temple recommend holder. But to imagine that everything that he's been doing and the story of a beautiful woman, I haven't deserved this, neither has my children. And the only thing I can do is just let life happen as it plays out. But I will keep stating the truth and facts of what's happening live. It isn't my story that I'm dealing with live, as the shock of knowing that my mom felt like I was good and secure. The last thing she really said is that you got all of this. Knowing that I have an IRA, she made sure that I knew that I have stocks and I have an IRA and I have money for me. But to imagine the following events that have happened as I kept waiting for my brother, as I thought executor, to be in my best interest to communicate legally. But literally during my mom's passing, he didn't seem like he was planning on using any attorneys at all. Literally, I was told to leave the hospital by Dave, that said he was a chaplain, but did an LDS ceremony with my mom, put her in her LDS garments before they carried her to the cemetery there in Fillmore, where I was born, in Fillmore, Utah, where her burial / funeral, which they considered as a burial, because she didn't want a bunch of guests. She didn't want to incur a bunch of debt. But the idea that my brother, I just found an email from when I wasn't able to log in because of identity fraud, which is so crazy to deal with on top of everything else, that utilizing remote viewing and in your mind technology, that I have someone targeting me, erasing all my pictures, decades of pictures. I mean, logging into my emails and erased off my YouTube, my videos off YouTube. I mean, to now be told by attorneys to take down my videos. I mean, the amount of silence, I feel so gaslit. I think the fact that I did notify my attorneys I will not take them down, and that I will keep telling my story. I will be publishing my story, every single bit of it. God bless America. To truth and justice in America. I'm out of West Valley City, Utah. 84120. This is Susan Sheppard's Augmented Reality of Diamonds in the Sky, Susie Q. Shep, live on the wire.